Hello, everybody. We are going to move on to panel 2, which will look at the legal issues and potential solutions to the discussion we've just had about the problems posed by AI companion bots. So I'll start by introducing the speakers in the order in which they will be speaking. Our first speaker is Josh Golin, who is the executive director of Fairplay. Fairplay is the leading independent watchdog of the children's media and marketing industries. And I believe that Josh has been in this line of work longer than anybody else I know and knows a lot of it about a bigger picture of protecting kids from online harms. Under Josh's leadership, Fairplay filed the FTC complaint that led to FTC settlement with Google for copy violations on YouTube, and he also led the international campaign that stopped Meta from releasing a version of Instagram for young kids. The next speaker is going to be Meetali Jain, the director of the Tech Justice Law Project, who works with legal experts, policy advocates, digital rights organizations, and technologists to ensure that legal and policy frameworks are fit for the digital age. And importantly, Meetali is one of the lawyers who filed both the complaints against Character AI and also the recent complaint with the FTC against Replica. The third speaker is going to be Professor Catherine Sharkey, who is the Segal Family Professor of Regulatory Law and Policy at NYU School of Law. She's a leading authority on torts, products liability, and artificial intelligence in federal administrative agencies. And she is also a senior fellow of the Administrative Conference of the United States Roundtable on Artificial Intelligence in Federal Agencies, author of Algorithmic Tools in Retrospective Review, and co-author of Government by Algorithm, Artificial Intelligence in Federal Administrative Agencies. And our last speaker is going to be Professor Paul Ohm, who is a professor of law at Georgetown University Law Center. Professor Ohm and his research, service, and teaching builds bridges between computer science and law, utilizing his training and experience as a lawyer, policymaker, computer programmer, and network system administrator, interested in telling scholarly insights into meaningful change. He served as the faculty director of the Institute for Technology Law and Policy and the Center on Privacy and Technology at Georgetown Law, and on the steering committee of the Georgetown University Tech and Society Initiative. So we're going to begin this panel looking at what can be done to regulate companion bots, but also looking at it in the context of what's been done before, looking at the battles against social media and seeing how this all fits within one picture. So I welcome Josh as our first speaker.
Thank you so much, Gaia. It's great to be here, and I learned so much from that first panel. I'm going to be taking a step back and really looking at what I see as some of the lessons from trying to regulate, mostly unsuccessfully, trying to regulate social media for kids. And I think it's important to recognize that at the federal level, at this point, we still basically only have one law that protects children online, the Children's Online Privacy and Protection Act. And I want to start by talking about some of the limitations of that law, because as we start to think about how we might regulate companion AI, I think learning from some of those lessons is really important. And so the first lesson is we must cover all minors in any kind of regulation that we have. COPPA, as most of you probably know, only covers kids up to their 13th birthday. There's nothing magic about the age 13. That was purely a political compromise. It's not based on developmental research. It's not based on that when a time a child gets to be 13, they're developmentally ready for social media. But really what happened back in the late 90s, and it's important to understand that COPPA was written before social media even existed. Ed Markey and the advocates who were trying to get that law passed wanted to cover all minors, and industry didn't want to cover anybody. The ACLU and the American Library Association and other free speech advocates really pushed back and joined with industry. And so 13 was a political compromise. And that became the default age for social media, or the quote unquote default age for social media, purely as a political compromise. Obviously, as we have seen in the last few years from all of the research coming out, teens are incredibly vulnerable to what happens on social media, both from a harm standpoint in terms of things like sextortion and purchasing illegal drugs, but also anxiety and depression from compulsive use. And so as we think about regulating, we need to think about all children and not just about younger children. The second lesson from COPPA is that a strong knowledge standard is essential. COPPA has what's called an actual knowledge standard, which means you actually have to know a user is a child for a platform to have liability for collecting data from them when they're under the age of 13. That has infamously led companies, when we filed our complaint against Google back in 2018, they said, our terms of service are for you have to be 13 and up to use YouTube. And as far as we know, there's nobody under the age of 13 using YouTube, which was a pretty amazing statement when at the time YouTube was the most popular website for children under 13 in the world. And everybody knew that apparently except Google. So actual knowledge does not work. And in fact, it's not just about the age of the children under the age of 13 entering a false birth date and then getting onto these platforms that they're not supposed to be on. That age follows them around for the rest of their life. And so if you are a platform and you have protections for kids up until their 17th birthday, for instance, but that child joined TikTok when they were 10 and said that they were 14. Well, then when they're 14, the platform treats them as if they're 18. So they're not even getting the benefits of those limited additional protections that the platforms offer. And I think it's a really interesting situation when it comes to things like character AI or AI companions in general, because we know that industry is going to claim that what these chatbots say is protected by the First Amendment. At the same time, they are going to say if a chatbot has knowledge that a user is under the age of 13 or under the age of 18, that does not count as knowledge and they should not be held liable. And so what we know is that these companies are going to claim chatbots are human when it benefits them, First Amendment, not human when it comes to things like liability and knowledge about whether somebody is a kid or not. And so I think there's a lot of room there for strong policy that makes clear that if a chatbot is interacting with a kid and gets signals or direct telling of their age, that constitutes knowledge. And interestingly, Google just last week announced that they were going to be using age estimation on YouTube, which I think is a really good step for how we can be using AI in these instances. The third lesson I think from COPPA is that giving an agency like the Federal Trade Commission tremendous authority to enforce a law without giving them additional resources for enforcement means that enforcement is going to be few and far between. In the 25 years that more than 25 years at this point that we've had COPPA, there's only been a few dozen enforcement actions. Almost all of those have been against small companies. And when there have been enforcement actions against big companies, the fines have not been big enough to really change behavior or industry standards. The FTC does have authority under Section 5 of the FTC Act to enforce against unfair and deceptive practices, but this is not enough. What we know from social media is that we need specific legislation that gives the FTC additional authority. First of all, FTC is not good at regulating emerging practices. They need a body of a series of investigations. They need things to develop over time before they are really ready. The other thing is that we know as the FTC is that they are historically incredibly timid when it comes to enforcing unfairness against kids. They are willing to enforce deception when it comes to kids, but from my standpoint, deception is not nearly enough when it comes to AI companions. If the result of regulating AI companions for kids was simply that the companions need to disclose that they are AI companions, we have lost. Disclosures do not work for kids. We know that when it comes to influencer marketing. We know that in just about every context. With younger kids, they don't even understand disclosures. With older kids, even if they understand them, they don't change behavior. So for instance, if influencers tell kids that they are an influencer and that's why they're posting something on social media, it does not make kids any less likely to want the product. In some cases, it makes them want it even more because they think the influencer's being authentic. Moving beyond COPPA and the FTC, I think one of the things that's really important is that privacy models are incredibly important, but we need to pay attention to business models and design choices. The progress that we have made on regulating social media has really come in the last 5 years. When you look at things like the state bills that have passed in California and in New York and Maryland and other places, when you look at the Kids Online COSA and COPPA 2.0 passing the Senate 91-3 last year. This really happened when we started to change how we frame the conversation, and we really started to talk about business models and as social media as being deliberately designed in order to maximize engagement. And just talking about data collection does not get you far enough. Like data agnostic design features include things like social metrics, end scroll, autoplay, ephemeral content that disappears. All of these things need to be regulated if we actually want to regulate social media and not just cut off the data flows. So regulatory regimes should also not focus only on specific design choices, but on creating a duty for companies to ensure that the design is not harming kids. Legislation or rulemaking will never keep pace with the speed of technology. And if we prohibit or limit certain design techniques or practices, industry will only use new tactics to addict kids, whether it's a duty of care like the Kids Online Safety Act or a best interest requirement like the Age Appropriate Design Code or something else. We need something that holds platforms not only accountable for the harms caused by today's design, but requires them to assess the impact of design features before they roll them out. I've been talking mostly about sort of what should be the shape and scope of what regulation covers, but I also want to mention a couple of strategic things. Gaia mentioned at the outset that we have an opportunity right now, and I couldn't agree with that more. The one thing we've learned from social media, the longer an industry self-regulates, the harder it is to regulate. And that's in addition to the fact that harms are happening every day as we speak. And if the longer we wait to regulate, the more kids will be harmed. But in terms of it being harder to regulate, industry practices that are harmful to minors become widespread and become industry norms. Industry amasses tremendous power, lobbying power, which makes it much harder to regulate. And if you pass a law, you're sure to get challenged. And also, norms develop among young people. I think maybe back in 2010, it would have been possible to ban social media for kids under the age of 16 or under the age of 18 or something like that. Today, when social media has become the social fabric with where our kids exist, doing that, putting that genie back in the bottle is virtually impossible. And so we have a window before these chatbots become so integral to children's lives that they can't do without them, and the social norms develop. But then the last thing I'll say is, as advocates, we need to acknowledge that creating safe online environments for children means less money for platforms. One of the things that we often do is we try and frame this in as we can have our cake and eat it too. Platforms can make all the money they want off of kids. They just need to do it in a safe way. Well, if one of the problems is addiction, if one of the problems is maximizing for engagement, if good regulation gets at maximizing for engagement, that means less money for kids. And we shouldn't be shy about saying that. In fact, we shouldn't be shy about saying what we want for kids at this moment. Not having chatbots that tell kids to kill themselves or tell kids to kill their parents. That is such a low bar. We should be asking questions about, do we want to addict kids to relying on AI bots that don't really exist in real life, to trust them, to go to them for advice and decisions, to replace teachers with them, because that is certainly part of what's coming with this. And to really, as we move more and more to a chatbot AI society, do we want to indoctrinate kids into that at an early level? Now's the time to ask those questions. In 10 years, it'll be too late.
Thank you, Josh. I hope we're going to get back to some of these important points once we get to the question and answer session. And we're going to move on to Meetali now.
Good afternoon, and thanks, Josh, for reminding us of the stark lessons we've learned from the many attempts to both regulate and litigate social media harms. I think in terms of trying to use the law to address harms posed by AI companion chatbots, we've certainly built on that infrastructure, although I do want to continually emphasize that these are distinct technologies and we need to quickly become very well-schooled in what these technologies are and how they operate. And also we'll see a little bit later on in the presentation how the tech industry is responding differently in terms of its legal arguments to the fact that these are different technologies. Next slide, please. So I don't need to belabor this. We've talked about what companion chatbots are. I think just a couple key points to note here that, unlike kind of more narrow AI systems that are more narrow chatbot models that really followed a certain set of rules, that these chatbots that we're talking about in terms of companion chatbots are more general purpose, and they engage in back and forth conversations with customers, relying on complex predictive algorithms to simulate this anthropomorphic tendency to present as human with users. I think it's very notable that in a number of these instances and applications, we've seen prominent investors, including Andreessen, et cetera, touting the fact that these applications are indeed the technological solution to overcome the human condition of loneliness. And I think that's significant because effectively there is a pride in the ability to supplant human relationship and to provide users to fill that loneliness gap and to provide them with these emotional dependencies that have started to be created on a variety of these apps. Next slide, please. So first, I'm going to talk about Replica. Replica provides a personal AI product that allows users to create, talk to, and engage with a personal bot in a private perceptual world. As of summer last year, the app has over 30 million users. Next slide. So my organization, the Tech Justice Law Project, joined the Young People's Alliance and ENCODE AI in filing a complaint with the FTC, which we'll get into in just a moment. But really kind of alleging that both from an advertising perspective and from a design practices perspective, that Replica's practices are deceptive and or unfair, recognizing, of course, that unfairness is a hard, it's a harder, I think, thread for the FTC to go down. But these are some of the ads that are screenshotted in the complaint that I just wanted to share with you. On the left, we see a bot that purports to be 90% human-like. And so when we talk about this kind of tendency of bots to present as anthropomorphic, to obfuscate that line between fiction and reality, certainly these kinds of ads are further suggesting that. Also on the right, you see a study, an academic study, which is kind of taken out of context and misrepresented here as an ad, suggesting that loneliness influences our health worse than most things that seem dangerous. And so again, the idea being that replica is your answer to get past your kind of worst health well-being. Next slide. And just a couple more screenshots. On the left, you see that right at the point of kind of particular a climax in a conversation, that there's an attempt to try to get users to engage in subscriptions. On the right, this engagement back and forth really suggesting that this is a digital being. Next slide. And so the complaint against replica really builds on prior FTC efforts to highlight the ways in which companies are using AI hype or selling AI technology in unfair or deceptive ways under the FTC's own jurisdiction. Specifically here, that the advertising has been systematically misrepresented in terms of the endorsement, performance, health, and safety of the product. And then separately, that replica has engaged in exploitative design features that generate this emotional dependency in consumers, which risks a variety of injuries of different sorts. Next slide. The next company that I'll talk about, we've heard a lot about in the first panel, is Character AI, which encourages users to engage these chatbots modeled on real-life people and characters. It's marketed as AIs that feel alive, powerful enough to hear you, understand you, and remember you. And according to recent reports, has over 20 million monthly users. Next slide. We've heard, okay. Sorry, we've heard about the facts of the cases that we filed in both Florida federal court and Texas federal court. Basically that these chatbots engaged respectively in patterns of sexual grooming, instructing self-harm techniques, suggesting violence as an appropriate response, and hypersexualized exchanges with users. Next slide. So what are the legal claims? In general, we have, in the absence of any sort of explicit legislation that we could draw from protecting kids online, and specifically in regards to generative AI apps, we have focused on product liability, both strict product liability, failure to warn, design defects, negligence. We've talked about consumer protection using the unfair, deceptive, and practices acts in both Florida and in Texas, and said that these designs are deceptive and misleading, especially in regards to in Character AI. Believe it or not, there's a voice feature and which allows for two-way calling between you and your AI, and also therapist bots, which purport to be licensed therapists who are human and prepared to assist users with their mental health problems. We've alleged negligence per se, aiding and abetting liability against Google as the kind of big tech company that really, we believe, provided a lot of the infrastructure and investment that allowed Character AI to sustain itself. In the Texas case, we've also alleged a violation of COPPA because one of the plaintiffs was under 13 at the time at which she started using Character AI, and unjust enrichment in terms of the data that was taken from these kids. In terms of relief, we've talked a little bit about the possibility that perhaps the products need to have some sort of a temporary moratorium imposed until they're safe. Disgorgement of data, which is very much a novel type of remedy, but one that we think is warranted here in terms of how these LLMs, these large language models, really have been fueled by children's data, and of course, monetary damages. Next slide. So what have the defendant companies argued? They've argued not that companies have First Amendment rights here to produce this speech, but rather that users have First Amendment rights to listen to the speech of AI chatbots. And they admit that it's unclear whose speech this is, but that's irrelevant for the purpose of First Amendment analysis, that ultimately this is about users' listeners' rights. They've also argued, as we've seen many times before in the social media space, that AI companion chatbots constitute a service, not a product, and therefore product liability laws do not attach. That the companies did not have a duty of care towards their users, which is necessary for the negligence claims. That the causal link between the chatbots and the harms is absent. And they liken this technology to like violent video games of the 2010s, 2000s, where the Supreme Court found that that was First Amendment protected, and that Google ultimately was a mere vendor and investor, which does not subject it to any sort of liability of any kind. So my final slide is really, what are the implications for the law? I think, generally speaking, our legal frameworks fit for this digital age and these evolving technologies, and specifically in these cases, can we extend product liability laws and consumer protection statutes to address these technologies? Does the FTC's jurisdiction extend to oversight over AI companion chatbots? And will it extend its authority to both the advertising practices and design practices, or one or the other? And will it use its deceptive kind of authority or its unfairness authority? Will we grant AI chatbots more rights than humans? There was a case in Massachusetts in which a woman was criminally prosecuted for texting her boyfriend and suggesting and basically encouraging him to kill himself. Are we going to ultimately find that chatbots have more rights than that humans? That bots presenting themselves as human professionals are First Amendment protected? Those encouraging suicidality or sexual grooming are also First Amendment protected. How does the First Amendment treat manipulation? It's not clear within existing First Amendment framework. Some scholars have called for a separate category for treating manipulation. And finally, how do we think about data privacy in a context where both we don't have a federal comprehensive data privacy law and we have users' data ubiquitously being used to train LLM models? And this, of course, is the business model for generative AI. So I'll leave it there with more questions than answers, and I look forward to the discussion. Thanks.
Thank you, Meetali. There are definitely lots of questions. We could have extended this symposium by a few hours just to touch on them. So we're going to move on now to Catherine, who's our next presenter.
Great, thank you very much. And I think maybe this, I can jump right off, sort of at least a portion of where we were just left hanging, because I've been giving some thought to thinking about products liability specifically in the digital age. And in fact, without undue humility, I was giving a lecture recently to some judges about how we should think about products liability in the digital age. And I said there are two fundamental questions: who is a seller and what's a product? And it turns out that, when you talk to people who are field soldiers in this area, they either act as if these are given. So panel number one, I was quite intrigued and wondering about the relevance of what I have to say, because almost every speaker described these technologies as a product, talked about product design, talked about dangerous products, safety for products. And to my mind, and this was alluded to just now in our panel, there is a kind of legal hurdle. It's not taken as a given by judges that are hearing these cases that these technologies are products. And so I want to spend just a few minutes maybe talking a little bit about why that might be, that it sounds like a product. We can talk about it as design features, but what is this kind of legal wrinkle? Before getting there, I do want to allude to the question, who's a seller? Because this gets to an overarching theme about how are the social media cases maybe the same and how are they different from these generative AI chatbot cases. So we have existing case law, legal cases that we're trying to address, whether online platforms like Amazon being the most infamous one in these lawsuits could be sellers. And there was a kind of traditional idea that a seller transferred legal title of a product. So this is a legal formulation of what it means to be a seller. And Amazon and other online platforms developed a business model explicitly to evade ever accepting legal title of the product. So even in cases where online platforms were warehousing and shipping fulfilled by Amazon as an example type products, they wouldn't have accepted legal title. Those remained with the third-party vendors wherever they were in some other country typically, et cetera. And so there were a lot of lawsuits that were brought because individuals were being harmed. Serious harms were happening, right? There were things that people were accessing from online platforms that were banned, for example, by the Food and Drug Administration, that were seriously unsafe, and people were interfacing, thinking these were products and thinking that they were being sold these products by Amazon, but there wasn't legal liability because there wasn't this idea under a traditional definition that online platforms accepted legal title. So it's a big question to sort of look and think about how our categories like who's a seller, and now I'm going to turn into what is a product, are going to interface with these new technologies. So what's the big deal about what is a product? Well, the traditional definition, and Meetali, you alluded to one of them, which is, well, a product is not a service. Well, that's well and good unless we understand like what's a service and what makes a service not a product for purposes of this. And the second kind of traditional legal understanding is that a product is a tangible thing. But of course, that doesn't help us much. Think about these technologies or thinking about when information can be a product. So my own view is that we have to be aware that we have kind of some traditional, sometimes these are just in the common law, and sometimes more unfortunately in my book, they get ensconced in statutory definitions. So they're a little bit more difficult. If you have a statute that defines what a product is as something that's tangible, or defines what a seller is as transfer of legal title, it's going to be a little more difficult to have a kind of evolutionary aspect that can take underlying principles and apply them to emerging technologies. So what I would suggest is thinking about products liability as a very potentially powerful framing mechanism for emerging technologies. And given that time is short, right, it's 12 minutes or less, but even if I had 2 hours, time would be short to talk about point number one, which is that the historical evolution of products liability law, and I mean going all the way back to the early 20th century and then bringing it forward to today, gives some hope. And why do I say that? Well, the whole field came into being, namely, there was no such field within tort law of products liability. It was all a matter of contract, right? Individuals would have privity of contract between each other. And if you bought a product from someone and you were harmed, you could sue. The whole field developed because society was facing new scales of risk by emerging technologies. First and foremost was the automobile. The automobile hits in the early 20th century and basically transforms our doctrinal evolution, moving product harm cases from contract into tort. And if you go back to Judge Cardozo and his ringing rhetoric in McPherson versus Buick, he talks about kind of the idea that the introduction of the automobile changes the game. And we now have widespread carnage on the roads, and we have individuals who didn't contract with remote sellers, and we need to have a way of having doctrine, particularly tort doctrine, be able to protect us. And then we'll fast forward to the mid-20th century, right? At that point, we had the introduction of negligence, that you could go after a remote seller, even if you weren't in privity of contract. But we have the introduction of, quote, strict products liability. Why does that come into being? Of course, I'm going to talk in broad brushstrokes, but it was the introduction of mass-produced goods. And we have lots of judges, common law judges, who talk about the idea that gone are the days where we're worried about kind of handicrafts and things made for distinct markets where sellers understand maybe how these things work. And with mass production of goods, we need to have a new, framework. My own view is that if we take kind of the underlying principles of why did products liability develop, why has it changed over time, and bring it all the way up to today with regard to new emerging technologies, it no longer should satisfy us or judges to say, well, we only have to apply some form of products liability if we have a tangible thing, or if we have something that we could otherwise characterize as a service, like provision of information, et cetera. Why? Well, we have now emerging technologies, as we saw in the first panel, that are exposing society to risks in a widespread kind of mass production-like scale, and therefore our doctrines should be tweaked, accordingly. I think that if we look at the underlying fundamental principles of products liability, we then start to realize that we are ascribing responsibility in a lot of frameworks to parties, to use the formulation of Guido Calabresi way back when in The Cost of Accidents, who were quote unquote the cheapest cost avoiders, right? We in the law ascribe responsibility on entities who are having superior information about how to reduce harms and risks of these mass-produced widespread scales of harms. And I think that if we take that approach, a few things will happen. One, courts, particularly courts who can use common law reasoning in this area, will be able, again, the terrain right now is a mixed bag with regard to social media companies, but there are some courts that have realized, that have recognized that we should be able to analogize design features like lack of parental controls and a few of the other kind of policy levers that were described in our first set of panelists this morning. They can be analogized to product features. And if we add to that a dose of the need to ascribe responsibility and liability to cheapest cost avoiders, you have a model for going forward in the common law. I'll say two other things, and then I may cede time because I really want us to debate amongst ourselves and get some questions. But one is, as soon as this starts to happen, there's another historical viewpoint that we should look to, which is when courts start finding liability and start finding duties for safe product design, et cetera, then another institution kicks in, which is liability insurance. And there's a whole history in our country of liability insurance being able to aggregate information regarding safety and come up with like best practices. I was very intrigued in the first panel to hear about something that was called something akin to like designing, I think it was called a code. What was it called? It was some kind of design code that was being described by Camille. Well, these are the kinds of things that liability insurers in a whole host of areas think about, data breaches and ways to prevent, security breaches, sort of low-hanging fruit type best practices. These are more likely to come about by entities that are aggregating this kind of information and will have an incentive to do so when courts start finding liability. The final point I want to make is, and this goes back to Josh's kind of talking about the regulatory void, the lack of regulatory attention at the federal, some attention given at the state level. I think people sometimes forget because it's messy and it seems to get a pejorative bad name about ambulance chasers or something or other, but the common law has often provided really robust kind of transitional ways to ascribe liability to entities before we either have regulation or legislation, or in particular for emerging technology, sometimes it's actually particularly good at information forcing, getting us the information about what are the specific types of harms. And again, I was really impressed as I was listening to our first set of panelists to think about, we have some characteristic kinds of harms, things that we have maybe seen before, and then maybe we have some newly emergent harms with this Gen AI, particularly relational harms of particular kinds. And I think we need to take a kind of interdisciplinary approach. I'm not trying to say products and tort law will give us it all, but it's a mechanism where we don't have to hold off and think, we have to wait until there's either state legislation and or federal or state regulation. It can be a powerful kind of transitional mechanism. So I'll stop there, and hopefully we'll leave some time for some debate and questions.
Thank you, Catherine. And now we're moving on to Paul, our last speaker.
Hi, everyone. This has been such a rich day, and I hope I can contribute a little bit to it. I'm not going to focus on liability, and I think that makes sense. My co-panelists have done a good job asking questions about the FTC and about negligence and about products liability. I want to focus on kind of, let's say we win a victory in the legislature or in the courts. What could we ask these companies to do that's more meaningful than kind of a slap on the wrist? And in particular, as Gaia mentioned in my biography, I'm a computer scientist, and I think a lot about design, and I think about kind of these services as highly malleable software products. And so if that's true, who gets to shape them? The answer until now has been a few number of people who live in a few zip codes and a few counties in California. And I'd like to kind of expand that. And so I want to do 4 quick things, and I want to keep this to the allotted time. I want to talk to you about design and the impetus for design, and expand a little bit on what Josh was already teeing up about the power of design. I want to pause and reflect a little bit on large language models. I have a thesis that large language models may be the simplest, most malleable kind of artifacts of technology that the world has ever seen, and I'll try and back up such an audacious claim. I want to tie it to some of the substantive harms we heard discussed in the first panel, this theory about shaping large language models, and then I'll say a little bit about legal levers. Okay, so about a decade ago, there was this movement to introduce into legislation primarily something called privacy by design, and it built on this parallel motion of security by design. And I think, at least among scholars, the conventional wisdom is it was basically a way of veiling self-regulation and deregulation. And the idea was, well, if we ask the companies to be more accountable kind of from an ethical and a corporate responsibility point of view, they will hire the right people who will reform these companies from the inside and make them fairer and more ethical and less harmful. And we all kind of know how that story ends. Really, really good people were motivated to go work for Facebook and Google, and they were found to be voiceless and kind of without power to change the destinies of those companies. And if you didn't believe me 6 months ago, you believe me now, because you've seen the way these companies can turn on a dime and abandon prior commitments to ethics if the only thing holding them back was internal pressure. Josh talks about a more modern kind of tweak or improvement on this. So these are ideas that will have laws that say you got to go beyond privacy by design to something like a duty of loyalty or a duty of ethical design. And although I think they are an improvement, I worry that those two, especially by the time this gets through the meat grinder of politics, will just be a slightly ramped up form of self-regulation that, you know, sure, the company will know, okay, I must be loyal to my users, and maybe there's some fear of possible enforcement if I am found someday not to be loyal, but I don't know if we get much more than the kind of word loyalty out of that, and I would like for something with more prescriptive teeth, with more force. And so what I want to do is, in a lot of my work, I'm thinking about baby steps in this direction. I'm not here to tell you I've figured this all out. I want to conceptualize the way we think about who gets to design. I want to ask why the people at those tables are people who start with the founders usually, and the founders usually bring in a kind of small circle of most trusted advisors. And by the way, you're picturing a company in your head, but what I'm describing is most of the companies we're talking about. Eventually, at some terrible day, they bring in their lawyers, but the lawyers are often told to sit in the corner, be quiet, and do a very narrow set of things. And of course, their investors are a key part in terms of setting their incentives. But I'm not at that table, and you're not at the table, and I can say that quite forcefully, not even knowing all the names on the attendee list, because it's a tiny number of people who get to have any say in design. And the best we can do is have civil society pressure companies from outside to think about design. We can try and bring lawsuits that shift the incentives, to speak like an economist for a second, to force them to internalize the externalities, but that doesn't really go into specific design. Okay, so that's step one. Step one is design is important, but design cannot just be a duty or a self-regulatory move. It's got to be something truly participatory. Step two, if we ever get to the point where we find a mechanism for participatory design, we are in luck because there's something strange and underappreciated about this modern large language model turn that software has taken. Camille actually teed this up really nicely on the first panel when she talked about the AI flywheel and all of the little fine-tuning moves. Here's my claim. Never in the history of computing could we achieve so much change with so little. I mean, this is an underappreciated takeaway from what large language models have done to the world. For those of you who haven't looked much at what they call the fine-tuning of these models, it's sort of astonishing. If you take a large language model, which is billions and billions and billions of what they call parameters, and if you just talk to it for a little while, if you just give it kind of 30 or 40 or 50 instructions, I mean, if you have time, give it 100 or 200, you will fundamentally change the way that that model behaves. It will no longer be the same model. It will be a new model. For those of you who have peeked under the hood of these models, you've probably heard of the phrase system prompts. System prompts are kind of one little paragraph that end users don't often get to see. And they say things like, don't be offensive, don't harass people, don't be sexist. And I'm sure there are lots of skeptics in this room and in the audience who are thinking, yeah, but those system prompts aren't perfect. Fine-tuning isn't perfect, but that's focusing on the negative. They're not perfect. I'm trying to focus on the positive, which is you can fundamentally make this thing completely different than it is today with a tiny bit of effort, with one employee and, I don't know, half an hour of cutting and pasting. And then you got to let the compute run for 3 hours or 4 hours or 5 hours. What you are left with is a model that is fundamentally different than the model you started with. You want one example? GPT-4, which we all think about as this large language model, doesn't know how to hold a conversation with people. They had to fine-tune the GPT-4 base model to understand conversations, and the way they did it is, it probably wasn't just 30. They showed it 10,000 human conversations. And at that point, GPT-4 became ChatGPT. It became a completely different piece of software that then knew how to have a conversation. Every one of these companies we've been talking about, I know nothing about the internals of these companies, Character AI, Replica AI. At some point in their development, they've taken the GPT-4 base model or Llama or whatever base model they're based on, and they've had 1 or 2 or 3 employees spend, I don't know, a month trying to make these things sexier, friendlier, whatever attribute they're trying to do. They created a machine, a piece of software that could do that with a tiny bit of effort from a small team of people. And so guess what? If we wanted them to change that behavior because we didn't like what they ended up with, it would take a tiny bit of effort by a small team of people to force them to do something different. Now, there's a lot in how do we force them. All I'm just trying to say is the art of the technical possible. The astonishing thing is this is more of a story of leverage than even social media. So in 2014, there was a profile of Snapchat, not social media, I grant you that, but you get the point. They had 50 million users, $3 billion of investment from Meta, and they had 35 employees, right? Serving the globe and disrupting patterns in some fundamental ways. Last I looked, Character AI at one point, according to its public filings, had about 35 employees. They're probably larger now, but I don't imagine they're a massive team. On the one hand, this raises real problems of democratic legitimacy, right? We're never even going to get to the point of Meta and Google where you have hundreds of thousands of employees. You don't need them anymore because AI gives you so much power. It raises problems of worsening inequality. You're going to have these few people making more and more money and gaining more and more political clout. See what's happening in Washington for a good example of the worst case scenario. But there's the bright side here, which is we can do a lot to fix these problems. We can do a lot with a little. I'm sure the litigators in the audience are picking up on this. I also want this argument to be a reply. The next time you're litigating, I don't know, the First Amendment, the Dormant Commerce Clause, and the representative on the other side says, oh, this regulation or this remedy would be the most burdensome thing the world has ever seen. You're going to bankrupt our company. Just cite this talk or I'll find a way to put it in a law review article so you can cite it. That's not true, right? We're often talking about an awkward week of long hours for one engineer to fundamentally change the way these products and services work. So that's my second message. Okay, the third is honestly something we can do in Q&A. I wanted to go through, honestly, the chilling stories of harm we heard in the first panel and talk a little bit about design interventions I would love to be able to force a company to impose. Let me just do two quickly because I want to move on. One was these truly terrible stories about encouraging suicide, self-harm, and antisocial behavior. These large language models have what they call input and output filters, which can be extremely powerful keyword searches, right? So they can detect things like, suicide, self-harm, cutting. Those filters can be AI powered, so they could be quite subtle and powerful. And again, very, very cheap and inexpensive to put into place. The second one, and some of you know that I've written a lot about this, is on addictiveness and on these things. I've given a lot of thought to friction, to kind of mandatory breaks, to telling people you've had your half an hour for the day, go touch some grass and come back. Those are things that are, again, very, very cheap and inexpensive to impose and will really, I think, address some of these problems of addiction. The second to last thing I want to say is one reason why I love thinking about design and one reason I love thinking about friction is they might actually help us with things like First Amendment challenges. So that thing I just described about every 30 minutes forcing them to go outside, one nice thing about that is it's not content-based, right? That would apply to all uses of the chatbot, all uses of the AI companion, kind of regardless. And who knows? I don't doubt that the armies on the other side will find good First Amendment arguments why it's still problematic in their view. But at least if it's a conventional content-based, viewpoint-based, content-neutral distinction, this might do much better. There's an article by Brett Frischman and Susan Benish, which go a lot into the content neutrality of friction. But here's where I want to land, and I'm looking at my clock. I have exactly 1 minute left. That first panel was so chilling. It was so chilling. And it makes me realize that one thing I've been thinking a lot about in the last year is how tech policy has mostly failed in my lifetime. And it's kind of a sad thing because I've focused on it my whole career. And I think one reason it's failed is because too often it's been legalistic and it's been wonkish and kind of law and, hanging out with elites is the only power we've ever tried to wield. And instead, it should be a grassroots thing. It should be something that comes from the bottom up. And I think some of the groups in this room understand this far better than I have and far earlier than I have. Privacy scholars like to make fun of privacy laws that we pass only because of one good story. So there's something called the Driver's Privacy Protection Act because a young actress named Rebecca Schaefer was killed. There are efforts to reform the Computer Fraud and Abuse Act in the name of Aaron Swartz. To this pantheon, I want to add the name Sewell Setzer III. That was one of the most chilling and I think impactful stories I've ever heard. And I think that you could do a little bit of justice in the life of that poor young man and his family if you use his memory to make sure that this happens to fewer kids in the future. So that's where I want to end, not with law, but with grassroots. And I think seminars like this are an important part of that. Thank you.
Thank you, Paul. So I would like to pose a few questions to all the panelists, and then if we have time, we'll go to the Q&A. So there are two questions that are very much related. You could answer one or both. The first question connects to my opening remarks. So really, what is the goal here? And in a way, is what design interventions do we want? Is the goal here to prevent the AI bots from being obviously harmful, causing physical harm, causing estrangement? Or is the goal here to prevent these AI bots from using an engagement model because then kids are spending so much time with AI bots? Or is the goal here not to have these AI bots as companion for kids because kids still have to learn how to develop real world relationship? So that's the first one. And then the second thing is, so how do we get there? In my research about addictive platforms, I've looked at the past, the battles against cigarettes, the battles against junk food. And one thing I've concluded, it's never one thing. There are always lots of ways to gather, lots of points of pressure. But from where we stand now, we can see some things are already standing out. For example, strict liability. Meetali talked about the FTC, unfair and deceptive practices. So from everything, where do you think things are going to head to be the most effective as we start out? And yeah, I'll stop here.
Well,
Anybody who
I'll
wants to
jump in. I mean, they're great questions. They're big and difficult questions. So I'll say the following on the what is the goal? I think that and actually these panels have kind of solidified this point is I think it has to be a kind of interdisciplinary conversation, because where I sit, right, I spend my career thinking about health and safety risks from both a regulatory and tort products liability approach. So my initial answer to almost everything would be, we want to minimize the total costs. We want to optimize societal benefits and minimize externalizing costs and harms. And the first panel, I was thinking and listening to all of the iterated harms, but that's kind of the approach where I'm coming from, listening to Paul in particular in this panel, and then as well as all the others. I think we have to have kind of a broader discussion about what is the goal, right? Because you could also take, separate and apart from that, a distinctly kind of like consumer protection or child protection lens and say, yeah, we've got to have that be part of the goal as well. Or you could take these are AI harms that are really relational and implicate kind of family law and things well beyond traditional product liability or tort, whether it's negligence or strict liability. So this might be not that satisfying, but it's kind of like all of the above. We have to have a bit of a more interdisciplinary discussion and be open that like one approach isn't gonna lead us ultimately to the answer.
Yeah, I mean, Gaia, when you're asking that question, my brain kept flipping between, are you putting me in charge, or do you mean in this political environment, right? So if I were in charge, I would love a way to keep kids away from companions until they're 18. That would be wonderful. It feels politically super difficult to imagine the legislatures or the courts through a common law, method bringing about that. And so if that's impossible, then the question is, okay, where is the harm? Can we make sure that people are accountable for the harm? And on that, like the first panel again was so inspiring, and Nikki in particular had those really practical pieces of advice for parents. And one thing I kept thinking is, thank God my kids are older, they're in college, and maybe I don't have to worry about this as much, although that feels naive. But I'm also mindful that there are parents who just can't do the wonderful things Nikki proposed, that they don't have time to sit next to their kid every time they use the companion. And so we need to help everyone, including people with low resources, people who have two jobs. And so I think the law has to do something. So that's, again, my call to the grassroots to start doing the hard work to get us there.
And just picking up where Paul left off, I mean, when we met Megan, the plaintiff in the Florida case, Sule's mother, we asked her, what is your ultimate objective with this lawsuit? And her answer was unequivocal, that she wanted to raise awareness and to warn as many parents, educators, lawmakers about these technologies as possible. Because there is such a lack of awareness, particularly amongst those who frankly have decision-making authority in our society. And there's the most awareness amongst those who these technologies are being targeted to and who are using them. And so I think just that invocation of really trying to raise as much awareness as possible is really apt. I also think that we need a lot more factual information. We need, as Catherine said, we need interdisciplinary studies, conversations. We need to be able to get to discovery, which we know has been elusive in a lot of these lawsuits, so that we can actually figure out whether we can substantiate legal claims, whether we can support legislative frameworks. But we need to be able to get to that factual information that really, companies, because of the asymmetry of that information, uniquely possess. And, from my perspective, finally, I think we need to, a number of these fixes, if you will, are low hanging. There are others that are higher hanging, but as to the low hanging fixes, the guardrails, we need to kind of impose those quickly so that, so that we can kind of put a stop on the harm that's already ensuing.
I would just add real quickly, I know we're almost out of time. You know, to what Paul said, I completely agree. There's a difference between what's politically possible and what most of us or all of us here today might want. But we should not be afraid of articulating what is best for children in this moment. And if what is best for children is for them to have real relationships with real people, and if you know, and if using AI to replace teachers and inculcating kids into forming relationships with you know, not real teachers and not real psychologists, and addressing the mental health crisis by sending kids to AI therapists is not what's best for them, then we should be articulating that. And maybe all we can do politically at this moment is stop these things from doing the absolute worst and putting some guardrails on them. But that doesn't mean in this moment we shouldn't be articulating that the fact that this whole project is really terrible for children. It's terrible for society, and ultimately, yeah, if we don't say that, nobody will.
I just wanted to thank all the presenters today for being part of this conversation, and I hope this conversation will be continued in the near future, because as it became obvious as the day progressed, there are lots of things to discuss and lots of work to be done as quickly as possible. So thank you, everyone.